I was asked to talk about the international and domestic legal regime of seabed mining, which is impossible to do in 8 minutes. So I'm just going to introduce you to some selected legal aspects and instruments that are linked to the environmental considerations that are at the heart of these controversies. And I start by saying that it is entirely the prerogative of Norway to decide whether or not to engage in seabed mineral activities. And this is because, according to the law of the Sea Convention, Norway has sovereign rights on its continental shelf and also the exclusive right to explore and exploit its mineral resources. Now, this does not mean that Norway has a carte blanche to just pursue seabed mining activities at any cost or with complete disregard for the marine environment. Both international and domestic law place some constraints or parameters, both substantial and procedural, under which Norway can exercise this right. And there is a plethora of international legally binding and non-legally binding instruments that prescribe such, let's call it, constraints, but also that help better understand what are the exact obligations concerning nature conservation or protection of the marine environment. And again, I don't have the time to tell you what all of these are, so I'm just focusing on some key obligations in the law of the Sea Convention. And the overall takeaway here is that while Norway does have the right to engage in seabed mining activities, it must at the same time comply with obligation to protect and preserve the marine environment. Norway must also adopt all measures necessary to prevent, control, and reduce pollution arising from mining activities, must also ensure that these activities do not cause transboundary harm to other states or other areas beyond Norway's jurisdiction, and must also adopt measures necessary to protect and preserve fragile ecosystems and habitats, which is particularly relevant here because, as Mette showed in the map before, some of these areas overlap with particularly vulnerable and variable areas. But note also that these obligations are obligations of conduct, specifically obligation to act with due diligence. They're not obligations of result in terms of environmental protection. So what this means is that Norway, moving ahead with seabed mining, and particularly exploitation, must have in place a system which includes rules, administrative procedures, and enforcement mechanisms necessary to regulate these activities, and also a system that enables the exercise of adequate vigilance over the activities of the licensees. So at the moment, Norway's regime rests chiefly, although not exclusively, on the Seabed Minerals Act, which, although does frame the basic tenets for seabed mining activities, particularly the licensing, is not enough. And a lot will depend also on the content of the regulations that were just mentioned a while ago, that the ministry is developing. So there are three other obligations that lie at the heart of this discussion. The obligation to conduct an impact assessment, given the risks of seabed mining, and I will get back to this one further ahead. Norway must also adopt a precautionary approach. And here I note that while a precautionary approach does not from the outset prohibit mining activities from taking place altogether, they are still an integral component of this due diligence obligation. And a precautionary approach may also restrict the margin of discretion that Norway has in terms of environmental impact assessments. So meaning that if Norway does not adequately account for the risks of seabed mining, even in the face of limited scientific data, or if the impact assessments are poorly conducted and in disregard of the precautionary approach, Norway could be found in breach of its due diligence obligations under the law of the Sea Convention. So Norway is also obliged to abide by the principle of sustainable development, which encapsulates essentially key four elements. First, the need to protect, preserve natural resources for the benefit of future generations. The need to exploit these resources in a manner that is sustainable or prudent, meaning inter alia that it's in a way that does not lead to its rapid exhaustion of these resources, or in a way that requires investing a part of the profits generated by mining into Other solutions or substitutes that fulfill same material needs, and this is a hint at circular economy, must conduct also in a manner that does not put at risk the collapse of living marine resources or that destroys the capacity of regeneration of ecosystems. And third, it also speaks to the need to take into account the needs of other states. And fourth, the need to ensure that environmental considerations are integrated into socio-economic development plans, and also vice versa, any measures undertaken to protect the environment must take into account their economic and social implication. Now, it's a principle that requires balancing and finding compromise between these competing considerations, and there is no express or clear priority given to environmental considerations. Finally, another obligation that Norway has is to adopt laws concerning pollution from seabed mining that must be at least as effective as international rules, standards, practices, and procedures, meaning that Norway must here follow very closely what the International Seabed Authority is doing in this respect, because they already have in place such regulations, etc., concerning the phases of mining, of survey and exploration, but they don't yet have the final drafts and regulations, etc., on the exploitation phase. These are currently being negotiated. So if Norway then fails to adjust its legislation according with what the ISA is developing, it could also result in a breach of its obligations under the Law of the Sea Convention. So within domestic law, here I just start by pointing out that Article 112 of the Constitution does place a positive duty upon the state to refrain from engaging in environmentally destructive or unsustainable activities. However, we have shown in the climate case that you might have heard, the Supreme Court really underlined that the threshold to set aside decisions that the Parliament has taken or adhered to is exceptionally high. Only in cases of gross negligence to adopt measures required under this provision would there be room for judicial review. Seabed minerals must also here have the great focus of the Seabed Minerals Act. Obviously, it's the key instrument. And also it incorporates some of Norway's obligations in international law. So for example, when we see in the provisions prescription that mining activities must be facilitated in a manner that comprehends these different interests of value creation, environment, business, etc., or that may have to be conducted in a prudent manner, this speaks to elements of the principle of sustainable development. Still, there is little guidance on how exactly all these interests are going to be balanced. Another key requirement of this act is the obligation to conduct the impact assessments prior to the opening of the activity on the continental shelf. This has been done. The problem is also that this provision is incredibly vague, and it does not clearly explain what the content of the impact assessment must be or the level of detail that is required for such assessments. And this is a problem also because this is the only provision that expressly and directly applies to impact assessments concerning seabed mining. Norway has other instruments that have further information on this, but because of their geographical or sectoral limits of application, do not apply to the seabed mining. But of course, they can be used as an interpretational aid, and so can EU law and the ESPO Convention and Protocol, to which Norway is bound to. But again, these instruments, they have information on the content of impact assessments and what it should focus on, but again, do not provide a clear guidance on the level of detail that is deemed sufficient before a decision is made. Now, the Norwegian Supreme Court has also given some guidance on this in the previous climate case. I'm not going to read all of that, but the main idea is that the larger the consequences and the impacts of a certain activity, the more thorough the assessment has to be. What has been questioned in this case is if, in this assessment, is that has the assessment been thorough enough to enable the decision to open for seabed mining? Finally, just before I conclude, another key instrument of domestic law is the Nature Diversity Act, because it enshrines the obligation for Norway to observe these decision-making principles when deciding on seabed mining activities. So knowledge-based decision-making, the precautionary principle, ecosystem approach, cumulative effects. And here I will only highlight that the level of knowledge that is required must be reasonably proportionate to the nature of the case, seabed mining, and the risk of damage of biological and landscape diversity, which means here that we do not need to have full knowledge of the risks and potential impacts of seabed mining before making a decision whether to engage in these activities or not. But I would argue, and also in view of precaution, that requires that we still need greater knowledge, particularly before licensing any exploitation activities, given the risks of this activity. So just then to conclude, because I've already received some questions on this, and some of you are aware WWF is engaging in a case against the states, just a quick observation that here the critical question will again concern whether there is sufficient or lack thereof concerning the impact assessment that form the base for the decision to open. And again, this hinges on clarifying what degree of knowledge is necessary, the content of the impact assessments, the level of detail in the assessment that is required. But I would also add in terms of the overall quality and credibility of the assessment, because there were some aspects raised during the public consultation phase that hint that the assessment may have some other more substantive shortcomings to it. And I will stop here so that I don't go over time. Thank you very much.